Thank you for listening to the Council of Institutional Investors Voice of Corporate Governance. I'm Jeff Mahoney, General Counsel of CII. The purpose of these monthly episodes is to update CII members and the general public on significant developments in corporate governance, capital markets regulation, and CII's related advocacy activities. This update covers a period from February 5th to March 4th, 2025. The following is my top 10 list of events over that period. Number 10, on February 20th, the U.S. Government Accountability Office issued a report finding that the structure and amount of executive compensation packages at Silicon Valley Bank, Signature Bank, and First Republic Bank, which all failed in 2023, were in line with their peer banks. As a result, the report strongly recommends that the U.S. Securities Exchange Commission and other federal agencies jointly prescribe regulations or guidelines to implement Section 956 of the Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010 as soon as practicable. The report points out that the top executives at the three failed banks received stock bonuses totaling about $130 million from January 2021 to March 2023. The publication notes that one bank paid bonuses to executives on the day it failed. Section 956 of Dodd-Frank requires the Federal Reserve, Federal Deposit Insurance Corporation, the Office of the Comptroller of the Currency, the National Credit Union Administration, the SEC, and the Federal Housing Finance Agency to adopt regulations overseeing performance-based bonus arrangements at banks with $1 billion or more in assets that could incentivize inappropriate risk-taking or excessively compensate bank executives. All six agencies first proposed a rule in 2011, but later abandoned that effort. Another proposal surfaced in 2016, but that too was tabled. Last May, the Federal Deposit Insurance Corporation, Office of the Comptroller of Currency, and the Federal Housing Finance Agency proposed rules that would prohibit incentive-based compensation arrangements that do not include risk adjustment of awards, deferral of payments, and forfeiture and clawback provisions. The prohibitions also emphasize the role of sound governance and risk management control mechanisms. The rules include disclosure requirements to help regulators monitor and identify areas of potential concern to banks. U.S. Government Accountability Office report concludes that by finalizing regulations or guidelines, the agencies would ensure compliance with Section 956 and better prevent compensation practices that can undermine the safety and soundness of large financial institutions. U.S. Government Accountability Office's support for rules implementing Section 956 contrasts with the vocal opposition to the rules from other sectors. Soon after the rules were proposed in May, groups representing financial institutions and members of the U.S. Senate Banking Committee publicly opposed them. American Bankers Association and three other groups sent a letter on June 18th saying the rules establish a rigid one-size-fits-all approach to compensation arrangements that will deprive institutions of the flexibility necessary to implement and adjust compensation practices that are appropriately risk-sensitive for the particular organization's activities and risks. Number 9. President Donald Trump signed an executive order on February 18th that requires all federal agencies, including the U.S. Securities and Exchange Commission, to submit draft regulations for White House review. The only exception would be the monetary policies of the Federal Reserve. Agencies also will be required to consult with the White House on their priorities and strategic plans, and the White House will set their performance standards. Furthermore, the executive order says the president and the attorney general will interpret the law for the executive branch instead of having separate agencies adopt conflicting interpretations. The executive order adds that the Office of Management and Budget will adjust the apportionments of independent agencies like the SEC to ensure tax dollars are spent wisely. The following day, on February 19th, President Trump filed another executive order instructing the leaders of all agencies, including independent regulatory agencies such as the SEC, to identify and provide to the Office of Management and Budget's Office of Information and Regulatory Affairs a list of regulations that the order says meets the following 7 conditions. 1, raises serious constitutional difficulties. 2, are based on unlawful delegations of legislative power. 3, are based on anything other than the best reading of the underlying statutory authority or prohibition. 4, implicate matters of social, political, or economic significance that are not authorized by clear statutory authority. 5, impose significant costs upon private parties that are not outweighed by public benefits. 6, harm the national interest by significantly and unjustifiably impeding technological innovation, infrastructure development, disaster response, inflation reduction, research and development, economic development, energy production, land use, and foreign policy objectives. Or 7, impose undue burdens on small business and impede private enterprise and entrepreneurship. The executive order also directs the Office of Information and Regulatory Affairs to consult with agency heads to develop a unified regulatory agenda that seeks to rescind or modify these regulations as appropriate. Number 8, on February 11th, acting U.S. Securities and Exchange Commission Chair Mark Ueda announced he was requesting that the U.S. Court of Appeals for the 8th Circuit pause arguments in the case contesting the SEC's climate disclosure rules. The acting chair said he was doing so based on the recent change in the composition of the commission and a presidential memoranda freezing federal regulations. All of the lawsuits challenging the rules, which were filed in 6 different circuit courts, were consolidated into one suit on March 21st through a lottery. The 8th Circuit was designated as a court to hear that suit. The SEC issued an order April 4th pausing implementation of the rules pending a decision on the regulations by the 8th Circuit. Acting Chair Ueda said that the rule is deeply flawed and could inflict significant harm on the capital markets and our economy. Both he and Commissioner Hester Peirce voted against the rule's adoption, arguing that it required a mandate from Congress that the SEC did not have. Acting Chair Ueda said he does not agree with the briefs that the Commission filed in the 8th Circuit defending adoption of the rule, and he questions whether the agency followed the proper procedures under the Administrative Procedure Act when adopting the rule. The acting SEC chair said the pause in litigation will allow the Commission to deliberate and determine the next steps. SEC Commissioner Carolyn Crenshaw issued a statement strongly disagreeing with the acting chair's action and asserting that the SEC acted within the boundaries of constitutional and statutory authority. Commissioner Crenshaw added that the only things that have changed since the rule was passed have been matters of politics and not substance. As such, I disagree with the position unilaterally taken today by the acting chairman. Number 7, on February 12th, the staff of the U.S. Securities and Exchange Commission issued a staff legal bulletin that addresses SEC Rule 14A-8I5, the economic relevance exclusion for shareholder proposals, and SEC Rule 14A-8I7, the ordinary business exclusion for shareholder proposals. Looking at the economic relevance exclusion, the bulletin emphasizes that SEC staff will focus on a proposal's significance to the company's business when it relates to operations that account for less than 5% of total assets, net earnings, and gross sales. It explains that proposals that do not meet the 5% criterion but have a social or ethical significance may be excluded. If a proposal's significance to a company's business is not obvious, the proposal may be excluded unless the proponent can provide information demonstrating that the proposal may have a significant impact on other segments of the company's business or subject the company to significant contingent liabilities. The possibility of economic harm is not an indication that a proposal is significantly related to a company's business. Notably, the bulletin says staff would generally view substantive governance matters to be significantly related to almost all companies. When interpreting the ordinary business exclusion, SEC staff says it looks at a proposal's subject matter and the degree to which a proposal micromanages a company. The bulletin explains that it will take a company-specific approach, considering factors such as the nature of the proposal and the circumstances of the company where it is filed. Specifically, it says when a proposal prescribes specific actions that the company's management or the board must undertake without affording them sufficient flexibility or discretion in addressing the complex matter presented by the proposal may micromanage the company to such a degree that exclusion of the proposal would be warranted. SEC staff provide a couple of examples showing what it regards as micromanagement and what it considers permissible. The SEC staff says we agreed that a proposal seeking annual reporting on short, medium, and long-term greenhouse gas targets aligned with the greenhouse gas reduction goals established by the Paris Climate Agreement to keep the increase in global average temperature well below 2 degrees Celsius and to pursue efforts to limit the increase to 1.5 degrees Celsius was excludable on the basis of micromanagement. By contrast, proposal seeking a report describing if and how the company plans to reduce its total contribution to climate change and align its operations and investments with the Paris Agreement's goal of maintaining global temperatures well below 2 degrees Celsius was not deemed excludable. To comply with the new directives on ordinary business, Attorney Con Hitchcock advises proponents to take 3 actions. 1, keep the requests at the policy level and avoid specifying details that could be viewed as micromanagement, i.e. proposals for specific timeframes or methods for implementing complex policies. 2, make sure the proposals are relevant to the specific company, not a matter of more general policy interest. And 3, for executive compensation proposals, make sure that proposals are limited to senior executives, that the practice in question is not widely available to the workforce, that the proposal does not seek to tie executive compensation to an ordinary business issue, and that the proposal does not try to micromanage the details. The SEC's bulletin is also notable in 5 ways. 1, it no longer asks companies to discuss how its board analyzed the shareholder proposal and reached the conclusion it did. 2, it provides guidance on the use of graphics in a proposal. 3, it suggests language that can be used to prove ownership. 4, encourages the use of email between a proponent and receipts of confirmation. And 5, reiterates the importance of proof of delivery. SEC staff plans to apply the new bulletin going forward. Companies and proponents may submit letters addressing points in the bulletin. In addition, companies may submit new no-action requests, even if the usual 80-day deadline is passed, if there is good cause, though they're advised to do so promptly. SEC Commissioner Carolyn Crenshaw blasted the changes in the bulletin, saying they create undue costs and uncertainty for investors and corporations alike. She added that this type of political policy shifting mid-season serves to undercut capital formation, not facilitate it. Number 6, the Shareholder Rights Group, the Interfaith Center on Corporate Responsibility, and As You Sow, sent the U.S. Securities and Exchange Commission a letter on February 18th. The letter urged the agency not to apply retroactively the February 12th staff legal bulletin addressing when companies can rely on Rule 14A-8I5, the economic relevance exclusion, and Rule 14A-8I7, the ordinary business exclusion, to omit shareholder proposals from their proxy statements. The letter says that applying new guidance to previously submitted proposals would unfairly penalize investors who followed the extant guidance in good faith, believing that they were following the procedures that would lead to clear results, limiting the need for the costly back and forth of the no-action process. The groups also point out that it is not apparent if the bulletin gives proponents the same leeway as companies to conform existing proposals to the SEC's new interpretations. The bulletin states that companies with pending no-action requests can supplement the request with new arguments or even late file no-action requests to take advantage of the new interpretations, but it's not clear whether proponents may make adjustments to their proposals. The letter points out that these types of bulletins were generally issued at the beginning of November to help ensure a fair and predictable shareholder proposal process. Groups urged the Commission to withdraw the bulletin until after the no-action season, or at a minimum, limit its applicability to proposals filed after the bulletin was issued. Number 5, on February 20th, the U.S. Securities and Exchange Commission announced the creation of the Cyber and Emerging Technologies Unit to replace its Crypto Assets and Cyber Unit. The Cyber and Emerging Technologies Unit is charged with combating cyber-related misconduct and protecting retail investors from bad actors in the emerging technology space. The new unit is comprised of approximately 30 fraud specialists and attorneys across multiple commission offices. Cyber and Emerging Technologies Unit focused on three priority areas, including one, fraud committed using emerging technologies such as artificial intelligence and machine learning. Two, regulated entities compliance with cybersecurity rules and regulations. And three, fraud involving blockchain technology and crypto assets. Number four, on February 27th, the Council of Institutional Investors staff issued an analysis of U.S. initial public offerings and dual-class stock structures. Analysis revealed the number of U.S. IPOs climbed 34% to 63 for calendar year 2024. Over the same time period, the share of companies going public with a single class of stock slid to 78%, down from 83% the previous year, and marking the second consecutive yearly decrease. Of the 28 companies that went public in the second half of 2024, 5 have dual-class structures with unequal voting rights. One stream adopted a 7-year sunset period, while the other 4 dual-class stock companies, Health and Tech, Service Titan, PWFG, and Venue Holding Corporation, did not adopt time-based sunsets to fully phase out unequal voting. One company, Service Titan, adopted a 15-year sunset trigger for Class B, which had 10 votes per share. However, through the authorization of a third class of non-voting stock, the company retained the option of indefinite misalignment between ownership and voting power. Despite the low adoption rate for time-based sunsets among dual-class companies in the second half of 2024, CII observed more adoptions than in the first half of last year. This resulted in an overall adoption rate of 43% for the year overall, which is an 18% increase from the 25% during the same period 2023, and is on par with adoption levels in 2022 and 2021. Number three, on February 17th, Delaware State Senator Brian Townsend, the Senate Majority Leader, introduced Senate Bill 21. If enacted, Senate Bill 21 would change Delaware General Corporation Law to essentially eliminate the need for controlled corporations to obtain stockholder approval to avoid judicial review of conflicted transactions with controlling shareholders. Conflicted transactions would have to be approved only by a committee with a majority of disinterested directors selected by the controlling stockholder. That committee would not be responsible for negotiating the transaction, and a 3-person committee could have a family member of the controller on the committee and still eliminate any judicial review. Controlling shareholders would be defined as those holding 1/3 of the voting shares of a company. Legislation contains more details about who would qualify as disinterested and controlling shareholders. Delaware Chancellor Kathleen McCormick relied on the fairness standard in a judicial review when she struck down Elon Musk's $56 billion pay package last year. Chancellor McCormick rescinded the pay, writing that although it had been subject to a shareholder vote, that vote was not fully informed because the proxy statement inaccurately described key directors as independent and misleadingly omitted details about the process. Chancellor also highlighted long and close relationships that Musk has had with members of Tesla's compensation committee. Following the decision, Musk publicly criticized Delaware courts and then reincorporated X, formerly Twitter, XAI, and Neuralink to Nevada, and Tesla and SpaceX to Texas. A handful of other controlling stockholders have now publicly stated that they are considering re-domiciling to other states, with few, if any, protections for minority stockholders. Some controllers, especially those running high-profile tech or founder-led firms, have threatened to move elsewhere. Some large law firms, allegedly attuned to that sentiment, are nudging the legislature to act. Proposed legislation also would limit the kinds of documents that minority shareholders are able to obtain through books and records inspection requests. Those shareholders will be limited to formal items such as certificates of incorporation or minutes of shareholder meetings, but would no longer have access to informal communications such as emails or other messages between board members and executives. Ann Lipton, Tulane Law School's Michael M. Fleshman, professor in business law and entrepreneurship, wrote in a February 17th business log professor blog that, quote, collectively, the changes represent a wholesale repudiation of Delaware's common law approach to rulemaking. The changes, if adopted, mean it will be laughably easy with a few incantations of magic words to create the appearance of procedural regularity, while shareholder plaintiffs will be denied access to the information necessary to establish any procedural irregularity. Timing and process of the bill are unusual since corporate law changes typically come from the Delaware State Bar Association Committee's work and are routinely approved later in the year by the Delaware General Assembly. In this case, Senator Townsend's bill is leapfrogged over the committee. General Assembly is expected to consider the bill in connection with its next legislative session, which begins March 11th. Delaware Constitution requires the affirmative vote of 2/3 of the members elected to each house of the General Assembly and the governor's signature to amend general corporation law. Counsel of Institutional Investors is in the process of reviewing the proposed legislation. Following that review, CII currently plans to send a letter to the governor sharing our views on both the process and substance of the proposed changes. Number 2, on February 11th, the U.S. Securities and Exchange Commission issued new guidance on submitting 13D and 13G filings. The new guidance explains that shareholders do not have to file a 13D as long as they certify they are not holding stock in the company for the purpose of influencing control of the company. Reporting on Forms 13D and 13G is required only by those shareholders holding more than 5% stake in a company. In determining if a shareholder is holding stock to change or influence control of a company and requiring a 13D filing, the SEC staff says it will consider shareholders' engagement practices. If shareholders engage with company's management, specifically call for the sale of a company or a significant amount of the company's assets, the restructuring the company, or the election of director nominees other than the company's nominees, the shareholders would be required to file a 13D. Furthermore, shareholders should file a 13D if they threaten to not support one or more of the company's director nominees if that company does not follow the recommendations to declassify its board, eliminate its poison pill plan, change its executive compensation practices, or take specific steps on a social, environmental, or political policy. Finally, a Schedule 13D should be filed if they discuss with management their voting policy on a topic and how the company fails to meet the shareholders' expectations on that topic, and then say they will not vote for one or more of the company's director nominees unless management makes changes to align with their expectations. And my number 1, most significant development in U.S. corporate governance, capital markets regulation for the period from February 5th, March 4th, 2025, occurred on February 26th, when at the invitation of staff at the U.S. Securities and Exchange Commission, yours truly had a call with SEC staff to obtain clarification on the February 11th guidance on submitting 13D and 13G filings. Following 13 questions and answers were discussed on that call, and our intent to provide more information about how the SEC staff plans to apply the guidance. The SEC staff on the call requested the following disclaimer. The views of the SEC staff do not necessarily reflect the views of the Commission, commissioners, or other members of staff. Staff views are not rules, regulations, or statements of the Commission. The SEC staff has neither approved or disapproved the staff's views. Staff's views, like all staff statements, have no legal force or effect. They do not alter or amend applicable law, and they create no new or additional obligations for any person. With that SEC staff disclaimer, CII question 1 stated, the Counsel of Institutional Investors, asset owner members, including public pension funds, are unlikely to ever be 5% holders. So for those CII members, how are they affected by the new guidance? SEC staff answered, unless they are beneficial owners of more than 5%, I do not expect them to be affected. CII question number 2. In the 2023 SEC release, Modernization of Beneficial Ownership Reporting, the Commission offered guidance as to what sort of joint activity is permitted without triggering a filing as a group. That guidance included communications with other shareholders, participation in a public forum, communications with an activist, and announcing how one will vote. Some CII members do not own 5% of company stock routinely engage in such conduct. Recent guidance did not cite the 2023 guidance. Can CII members continue to rely on the 2023 guidance, or does the new guidance change anything? SEC staff answer, 2023 guidance is not affected by the new guidance. They address different aspects of the beneficial ownership reporting rules. In cases where an individual exceeds the 5% threshold, the new guidance addresses circumstances in which they may be influencing control and disqualified from reporting on a 13G. The 2023 guidance addresses the formation of groups. The key similarity is that we do not aim to stifle engagement. We are not attempting to prevent companies from engaging with shareholders. We are also not suggesting that exchanging views should disqualify someone from filing a 13G. CI question number 3. Does the new guidance affect collective engagement vis-a-vis 5% ownership represented through Climate Action 100 plus members, for example? SEC staff answer. The free exchange of ideas should not be seen as problematic simply because they are acting collectively. However, collective actions may be a factor in determining whether an investor is influencing control. CI question number 4. Are the terms in proxy voting guidelines considered for assessing whether a shareholder is influencing control or exerting pressure as part of the new guidance, even when there's no direct discussion of vote intent during an engagement dialogue? SEC staff answer. The existence of the voting policy itself would not influence control. If they are asset managers, the mere presence of the policy does not disqualify them. CI question number 5. Would directing companies to an asset manager's publicly available voting guidelines that include references to director voting action disqualify the asset manager filing a 13G? SEC staff answer. Simply informing a company where they can find these guidelines without more would not result in disqualification. CI question number 6. If an asset manager publishes its rationale on a director vote before an AGM and notes its reasoning for supporting or opposing the director in question, would this disqualify the asset manager from 13G eligibility? SEC staff answer. If an asset manager merely indicates how it intends to vote and does nothing more, it will not result in disqualification. CI question number 7. Would writing a private letter to the board of directors stating an asset manager's vote intentions and rationale on a director election vote disqualify the asset manager for 13G eligibility? SEC staff answer. We would consider the purpose of the letter and other aspects of the engagement. The guidance applies to all forms of communication, not just in-person discussions. CI question number 8. The company has an upcoming vote pertaining to a merger or acquisition. Is an asset manager able to engage with the company and share its perspectives on the proposal in question? SEC staff answer. The asset manager can engage, but what is said during engagement with respect to that transaction determines whether a 13D needs to be filed. CI question number 9. Does the new guidance apply to engagements outside the proxy season? SEC staff answer. Yes. CI question number 10. Does the new guidance apply to non-U.S. investors invest in U.S. companies? SEC staff answer. It would apply to any person subject to the beneficial ownership reporting rules. CI question number 11. What event or events led the SEC staff to conclude the new guidance was needed? SEC staff answer. The current guidance was not as helpful as it could be, as it was providing a baseline. New guidance provides illustrative examples of circumstances in which a shareholder's engagement with management may cause the shareholder to hold the subject securities with the purpose or effect of changing or influencing control of the issuer and lose its eligibility report on Schedule 13G. CI question number 12. What type of activity would the SEC staff like the new guidance to change? And how would you determine whether the guidance has been effective in promoting that change? SEC staff answer. The new guidance is intended to facilitate regulatory compliance by helping investors understand the staff's views on what constitutes influence and control of the issuer that would disqualify you from reporting on a 13G. And finally, CI question number 13. Did the SEC staff seek input from any institutional investors in developing the new guidance? SEC staff answer. We do regularly engage with market participants, but in terms of publishing the new guidance, I am not aware of any institutional investors that we engaged with specifically to provide input on this guidance. That completes my monthly U.S. corporate governance capital markets update. If you have any questions regarding any of the issues discussed, please feel free to email me at Jeff, that's JEFF, @CII.org. Until next time, I'm Jeff Mahoney. Thanks again for listening to the voice of corporate governance.
Thank you for listening to this episode of The Voice of Corporate Governance, brought to you by the Council of Institutional Investors. The Voice of Corporate Governance is a free, non-sponsored podcast that highlights critical developments in corporate governance and other important issues affecting institutional investors. The views expressed by those interviewed on the podcast do not necessarily reflect the views of CII or its members. For more information on CII and its policies on corporate governance, please visit our website at www.cii.org.